The fourth question that's before this court is, was a recount ever completed given the registrar's failure or refusal to recount the provisional ballots, either manually or by means of the voting system used originally? The appellants contend that the recount was never completed because the 71 provisional ballots were not recounted either manually or by means of the voting system used originally. It's important to keep in mind that when Janet Nguyen specifically asked, as she was required to do by law, she asked for a recount of all ballots that were cast in the election in question. Not all ballots that were tabulated, all ballots that were cast. And no one suggests that the provisional ballots were not cast. The question is, should they have ultimately been counted as legal votes? This is no different than when you deal with absentee ballots. They come in an envelope, the signatures are compared to the records of the registrar, if they feel that they match, then they get dropped in. You're allowed to contest those decisions, argue to the registrar. If he doesn't agree with you, you can argue it to the trial court and bring it all the way up to the Court of Appeals. Now, what's uncontested is that these 71 provisional ballots were never recounted, as was requested by Janet Nguyen in her original request. It is uncontested that on election day, these ballots, again, were put in an envelope. They were read, they were compared to the voter rolls to see if signatures matched and names matched, and then some were counted and some were not. It is also uncontested that during the recount, these ballots were completely ignored, despite the request of the appellants that they be included in the recount. These votes which were cast were never compared a second time to the registrar's records to see if they were properly cast. The appellants were never given a chance to argue to the registrar why this particular ballot should have been opened and counted. Sections 15631 and 15632 specifically allow for a challenge to all ballots cast and for ballots to be added or subtracted by the registrar during the recount based on his rulings and challenges.
If I understand this correctly, when the registrar refused to look at the 71 ballots, the provisional ballots, and we weren't going to count those, because the registrar concluded that those voters were ineligible, your option at that point, if I understand the statutory scheme, is to go to court, get a court order telling the registrar to count those.
No, we do not have that option available to us. 14310 is the provision that I think you're thinking of, and that was agreed. That gives it a remedy solely to voters. It says that a voter who believes that their ballot, not anyone else's ballot, but just their ballot should have been counted, can bring a writ application up till the counting is done on election night, and can get their ballot counted. But that remedy disappears after election night, and 14310 gives that right solely to a voter as to their own ballot. There's no remedy under the writ remedy available, and the McKinney case makes it clear that writ relief is not available. We've covered that in our papers, and the California Supreme Court said in Friends of Sierra Madre that the grounds for the only grounds that you can bring for an election dispute are under the election contest provisions, and that those are, quote, exclusive. Just as it happens with absentee ballots, some of these ballots were disqualified. We don't really know the reasons because they were never put in, but they probably were disqualified for that very reason. But absentee ballots are disqualified for the very same reason, where they determined the person voted twice, once at the polls, once by absentee, the signatures don't match, somebody brought them in that shouldn't brought them in. There's a lot of different things that can cause a registrar to determine that there is that there's a ballot that was cast that should have been cast. But this, what the registrar has done is make his decisions entirely beyond any form of judicial review. What should have happened is they should have gone by the voting system used originally. They should have, again, gone through the process of comparing them. And if, in fact, let's say that it looked to someone like the signatures did match, they could argue that. In fact, in the area of absentee ballots, there were handwriting experts brought in to argue over that issue on absentee ballots. They should have had the same ability. And 15631, that's our remedy. It allows the appellant to argue to the registrar as to every ballot. They have the right to challenge every ballot cast. These were ballots cast, and Trung Nguyen should have given the opportunity, as was every other candidate should have been given the opportunity, to argue why it is that they should have been open. If he declines it, then it's part of the record for the trial court, for the election contest.